See the money won't stay for your meal, getting on a piece of pie for your wife. Everybody wanna know how it feels.
Murder reference, as you all understand, and it is clear from the term itself, it's a reference sent by the Court of Sessions to the High Court for the confirmation of sentence of death awarded in a murder trial as envisaged under Section 374 of the Code of Criminal Procedure 1898. The object of this reference is that two judges of the High Court should sit together and give a decision on the point of law as to whether the sentence of death is to be confirmed in the case or not. Chapter 27 of the Code of Criminal Procedure 1898 lays down the procedure for dealing with such proceedings. The proceedings of the Court of Sessions after the trial are submitted before the High Court under Section 374 CRPC. The High Court under Section 375 CRPC has power to make further inquiry and can record additional evidence. If it thinks fit, these powers can be exercised by the High Court itself, or it can direct the Court of Session to record such evidence. And the presence of the accused while recording such evidence may be dispensed with. I may share here that this exercise was once undertaken by a divisional bench at Rawalpindi High Court, headed by His Lordship Mr. Justice Falik Sher, in the case titled as Mola Baksh versus the State. When it was pointed out during arguments that the constable who had taken the rifle to the forensic science laboratory was not produced during the trial, the High Court summoned the constable and examined him in the High Court, and my Honorable Senior late Sardar Muhammad Ishaq Khan, he cross-examined the witness in the High Court. And this is the only occasion in my 27 years of career when this section was applied in the High Court. While dealing with the murder reference, the High Court has powers to confirm the sentence of death or pass any other sentence under the law which the High Court thinks fit is made out according to the facts and circumstances of the case. Or it can pass a remand order on certain illegalities having been found by it, or by amending the charge if necessary, and even can acquit the accused. If in the opinion of the court no offense is constituted on the basis of available material, these powers are identical to the powers available to the Court of Appeal under Section 423 CRPC. Chapter 27 of the Code of Criminal Procedure imposes a condition that two judges must agree on the question of confirmation of sentence of death. In case there is a difference of opinion, then under Section 378 of the Code, the matter is referred to a referee judge. The decision either to confirm the sentence of death or otherwise will be the final decision on the basis of majority. And this is the procedure prescribed for dealing with a murder reference in the High Court, that proceedings are submitted before the High Court, and High Court, while using its powers, make a decision on the question of the sentence and deals with the appeal as well. This procedure has been adopted after the centuries of practice in order to ensure that the capital sentence, which is the harshest attribute of the state, should be inflicted with great care and caution. For understanding how the murder reference should be prepared and presented before the court, one must understand the intricacies of the procedures of a murder trial. You have to understand the procedure of the murder trial at the first instance, because without having a clear concept of murder trial, its requirements of law, it is not possible to understand or present a murder reference before the High Court. After the conclusion of a sessions trial, if a sentence of death is awarded to one or some of the accused, the proceedings are submitted before the High Court under Section 374 CRPC, and appeal against conviction are also invariably filed in almost 99% cases. The accused who are unable to engage counsel, their appeal is preferred through jail authorities, commonly called as jail appeal. The copies of the judgment of the trial court are provided to the aggrieved parties free of cost in order to enable themselves to file an appeal before the High Court. In case of a death sentence, the appeal must be filed by the convict within 7 days under Article 150 of the Limitation Act 1908. Whereas period of 30 days is provided to the complainant for filing an appeal against acquittal under Section 4172A of the Code of Criminal Procedure. The complainant may also file revision for enhancement of sentence or compensation, for which no limitation is provided, but it must be filed within a reasonable time. All these matters are decided at the same hearing and mostly through a single judgment. Now the question arises, you have received the paper book and you, as a newcomer, you want to prepare a murder reference. You should keep in mind that before presentation before the High Court, what are the duties of a lawyer? The duties of a lawyer is to prepare his case with utmost efforts, with hard work, and present it before the court by raising all the grounds available, all the legal and factual grounds available, without expecting any particular result. This should be kept in mind. It should always be in your mind that you should not be result oriented. Your job is only to prepare and present the case before the court. The facts of the case should be properly prepared on a sheet which can depict the full picture of the case. When you take the notes of murder reference, the details of facts should be available before you on a sheet, which includes basically the FIR number, the date and time of occurrence, date and time of report, number of accused, their date of arrest, name of deceased, time of postmortem, number of accused with their roles and date of arrest, name of and age of deceased, name and number of prosecution witnesses, recoveries from the accused and from the spot, and the result of the forensic lab, if any, date of judgment, and sentence passed under the relevant law. That is also very important. All these facts must be drawn on a single anchor sheet so as to answer any queries which may be raised by the bench vis-a-vis the facts of the case. Because you might have seen when the reference is started, the court starts taking fact itself sometimes. And they ask you certain questions, place of occurrence, time of all these facts. So it should be readily available with you without opening the file. You should be able to state the facts before the court. One must minutely examine the record, which is in the shape of a paper book containing entire proceeding and record of the trial court, including order sheets. The paper books are prepared by the printing branch by experienced staff of the High Court free of cost and are supplied to the parties. After examining the paper book, one must ensure that the mandatory requirements of the trial have been fulfilled or not, which include, अब आपने जब ट्रायल कोर्ट का रिकॉर्ड देखना है कि ट्रायल कैसे हुआ है, तो जब आपको मालूम होगा कि ट्रायल में ये चीजें जरूरी हैं, in which documents are to be supplied under section 265C, the charge is to be framed, the witness's statement should be recorded on oath, statement under section 342, the defense the defense evidence, if any, and opportunity to provide defense evidence was given or not. All these things you have to look into it while preparing your brief. And the opportunity to cross-examine the witnesses was provided or not. Mandatory requirement is that the opportunity should be provided. If the accused fails to avail this opportunity, no benefit can be extended to the accused in such an eventuality, as held in a case of Zafar Iqbal. This was also a case belonging to Rawalpindi district, reported in PLD 2015, Supreme Court 307. In this case, the accused opted not to cross-examine the witnesses. He did not produce any lawyer, and the evidence was recorded. He was awarded death sentence, which was upheld by the High Court, and it was upheld up to Supreme Court for the reason that it was the opportunity was provided to him, but he opted not to cross-examine. So these things should also be taken into consideration. The statement of accused under Section 342 CRPC is also a very necessary and mandatory procedure, because in this statement, entire incriminating evidence in the form of questions are put to the accused in order to explain to provide him an opportunity to explain his position. The right to produce defense evidence of making statement on oath under Section 340 subsection 2 CRPC, and after going through the file, it appears that some evidence is available which ought to have been produced or has some bearing upon the fate of the case or the guilt of the accused. An application under Section 428 CRPC can also be filed for producing the additional evidence. As you all know, the system pertaining to criminal administration of justice in Pakistan is adversarial in nature, in which an accused is confronted with the charges and the onus is upon the prosecution to prove the allegation made in the prosecution case beyond reasonable doubt. What is a reasonable doubt? When a prudent person becomes doubtful of existence of certain fact or act committed by an accused offender or not. And if the prosecution fails to prove its case beyond reasonable doubt, then the accused is entitled for acquittal, not as a matter of grace, but as a matter of right. Plea advanced by the accused is not looked into as held in PLD 91 Supreme Court 520 and Fakir Muhammad case PLD 2011 Supreme Court 796. If it appears that the prosecution has been able to drive home the charge against the accused, and accused has also taken a specific plea, then both these versions are to be analyzed by placing respective pleas in a juxtaposition. The onus of proving plea on the accused is lighter as compared to the prosecution. The accused has to create a reasonable doubt in the mind of the court that his plea might be true or may be true. Even then his plea is to be given preference. This concession of maybe or might be is not available for the prosecution. Reference in this behalf may be made to the cases of Safdar Ali versus the Crown, a very famous case, and every person practicing on criminal side must go through this judgment. This citation is PLD 1953 FC, page 93. And as earlier told, Fakir Muhammad's case, PLD 2011 Supreme Court 796. In this case, His Lordship Mr. Justice Asaf Saeed Khan Khosa has elaborated these principles in a very articulate manner. How to begin with? It is always the FIR, First Information Report, is the basic document of every criminal case and a murder reference. It is called a cornerstone of a criminal case. You have to deeply go through it because it depicts the whole picture of the case, because it is the first information received about the occurrence, and you can judge many things and make out your case even from the bare perusal of the FIR. What you have to look into it, what was the time of occurrence? What was the time of report? How much was the distance between place of occurrence and the police station? And if it appears that there is a delay in the FIR, which is not plausible, which is not explained, then this gives rise to a legitimate inference that the witnesses were not available and they were arranged subsequently. And this is the reason the post-mortem was also delayed. On the basis of this, you can build up your case that this is an unwitnessed occurrence. The prosecution story was subsequently concocted. And if the FIR seems to be prompt, then you have to look for the loopholes in the prosecution case from other angles. If going through the file, keeping in view all the principles laid down for appraisal or reappraisal of evidence, that the prosecution case stand established, then you must have a second line of defense, which is normally on the question of sentence, whether the grounds of mitigation are available or not, and if available, on what grounds, and how one can seek reduction of sentence in a case under section 302 BPPC. 302 BPPC contemplates alternate sentences which are provided, and this aspect has been dealt by the Apex Court in the famous case of Ghulam Mahyuddin K, 2014 SCMR 1034. The grounds which may directly have bearing on the question of sentence includes failure to prove motive, inadequate motive, motive not directly attributable to the accused, or certain other factors such as motive remained shrouded in mystery, the non-availability of the independent corroboration to the ocular account, which may include a negative or an inconsequential recovery. The principles of appraisal and reappraisal of evidence should also be kept in mind, because the Sessions Court during trial, it appraised the evidence, and after appraisal of the evidence, it gives a finding. When the matter is brought to the High Court in shape of a murder reference, the High Court undertakes the exercise of reappraisal of evidence, in which the entire record is scanned except the judgment of the trial court. That is not looked into while dealing with a murder reference, because High Court has to form its own independent opinion on the basis of the available record. In reappraisal of evidence in a murder reference, you must concentrate on the legal loopholes. Usually in murder case, there are two types of evidence, either of eyewitness account or of circumstantial evidence. While assessing the ocular account, you must keep in mind whether witnesses are natural or chance. This is the first thing you have to look into while reading the evidence of the prosecution witnesses, whether there is any circumstance available on the file which makes the presence of the witness doubtful, keeping in mind the distance between the place of occurrence and abode of the witness or their workplace. Also see whether any plausible explanation has been furnished at the trial by the witness, in order to justify their presence and whether any corroboration to this effect is available or not. While judging the evidentiary value of an injured witness, one must keep in mind that the injured witness is not necessarily a truthful witness. The stamp of injuries on his person is a proof of his presence, but not a guarantee of the truth. There are so many references. Basic judgment is 81 Supreme Court 795 in 2011 SCMR 323. Another important aspect in determining the character of a witness is whether he is an independent witness or an inimical witness or a related witness, so that you are able to highlight his relationship with the complainant party and enmity with the accused. The most important yardstick for determining the evidentiary value of a witness, as declared by the Superior Court, is whether the story narrated by the witness is probable or not. This is the most important aspect while determining prosecution evidence during the appraisal or reappraisal of evidence. Then there are cases of circumstantial evidence. Circumstantial evidence usually comes when there is no direct evidence available, which is in the shape of law scene, Waj Takkar, extrajudicial confession, coupled with recoveries. Now another dimension has been added to the circumstantial evidence, which is the forensic evidence. And forensic evidence is very important to be read and understood. How the samples were taken, how much delay has been caused. Even today, if any one of you was present in the High Court, in the division bench, there was a case in which 5 persons were done to death. And the allegation against the accused was that his fingerprints were matched, which were obtained from the place of occurrence at the time of occurrence. But there was no evidence available as to when these were obtained and when these were sent. That chain was broken of the safe custody was not established. Therefore, the High Court had no other option but to acquit the accused, despite there being forensic evidence available. Usually, the traditional circumstantial evidence, the principle which has been settled on this point by the superior courts is that it should be in the shape of a chain. It should be so well connected that on one hand it should be touching the dead body and on the other hand it should be around the neck of the accused. And if any link is broken, the whole chain goes away. So you have to keep in mind the principles for the appraisal and reappraisal of the evidence before presenting your case before the court. Judicial and extrajudicial confessions are to be dealt with by the parameters laid down by the Supreme Court of Pakistan in Mujahid case. Most of you I know remember this case, 2016 SCMR 274. There are two recent judgments, 2021 SCMR 873 and 21 Supreme Court 600. There's another evidence which is in the shape of last seen evidence. Last seen evidence is basically a weak type of evidence, but it is to be gauged from the very beginning of the prosecution case as to when it surfaced, keeping in view the proximity of time of crime and place where the deceased and the accused were seen together. In appraisal and reappraisal of evidence, medical evidence also has its own significance. This evidence either confirms or negates the entire prosecution case. One can judge the time of occurrence while going through the medical evidence. وہ جو پوسٹ مارٹم کے ٹائم میں کتنا ہے between injury and death, between injury and post-mortem, the position of the dead body, the availability of rigor mortis, and so many factors such as stomach contents. These are important factors which can determine the time of death and which may either conform with the prosecution case or which may negate. It may, the number of injuries, locale and kind of weapon used, and the nature of injuries, whether it is a firearm, a blunt weapon, or an incised wound, and what are the attribution in the prosecution case, whether they are confirmed by the medical evidence or they are negated by the medical evidence. You have to judge it by going through the ocular account and keeping in view the medical evidence available on the record. Presentation of a murder reference is the ultimate test of a lawyer's skill. Always stay focused on your case, try to be in time in the court, and when you start presenting your case, start with the facts of the case as earlier discussed. In such a manner that the whole picture of the case becomes clear to the court. The details of the facts may be presented according to the queries of the court. After giving the facts, read the FIR, including the police proceedings. Police proceedings is also a very important document of the complaint and which is part of the complaint, which is oftenly overlooked. Many things can be derived out of the police proceedings, which may be even contradictory to the prosecution claim which has been set up initially in the FIR. And if the court permits to read the evidence or refer to those portions of evidence which supports your case, also demonstrate before the court the possible infirmities in the medical evidence. Thereafter, you may refer to the defense offered by the appellant at the trial. And once the reading of the record has been completed, the next step will be the formulation of arguments, in which you address the court by highlighting the legal grounds available to the accused, such as inordinate delay. Once you have completed the reading of the file, and the court may ask you to formulate how you would formulate your arguments. You will start, my lord, there is a delay in the FIR. So you should be able to point out at page number so and so, this fact is mentioned. And this witness has said such and such thing which goes in the favor of the accused. And then attack the witnesses. Point out, raise those grounds which makes the court believe that these witnesses were not present. And while it should not be mere argument, it should be developed from the record. There must be something available on the record on the strength of which you can say something in your favor, in favor of your client. All the available arguments which legally one can argue, do argue before the court and try to persuade the court to disbelieve the witnesses on the basis of the grounds which possibly could be related, inimical, chance, or ocular, being contrary to medical evidence, the recoveries being inconsequential, or there being no independent corroboration available to the eyewitness account, the motive part, and lastly turn to your defense and try to convince the court from the record that the defense version is more plausible. If during arguments of the other side some arguments are advanced and which you think requires to be answered, wait for your turn to rebut those. In this manner, you will be able to prepare your brief. Do observe the court proceeding regularly, especially the murder references which are being argued by the senior counsel, and try to learn how to present their case. This is how we used to do in our times when our senior used to present their case. I once again thank you, all of you, for being patient and providing me with an opportunity to share my thoughts. Thank you very much, sir.
क्वेश्चन ये कि मर्डर रेफरेंस एक बंदा अपील नहीं करता है, कॉन्विक्ट अपील नहीं करता, बट मर्डर रेफरेंस आ जाता है. Whether he should be put a notice to come or to engage a counsel or to bring a lawyer in court to defend your case, accused, convict.
It is the discretion of the court.
Discretion
of the court. It is not necessary.
Sir,
because if jail appeal is not filed, he has not opted to prefer an appeal, then murder reference is purely for the satisfaction of the court. Court has to see, two judges have to confirm this sentence. Two judges have to sit together and confirm on the point that this is a case of death sentence, then death sentence can be passed. अगर उसको नोटिस किए बगैर, और किसी को स्टेट काउंसिल भी अपॉइंट कर सकती है, इसमें कोई ऐसी प्रोसीजर ऐसा प्रोवाइड नहीं करता.
सर एक और जो क्वेश्चन है इससे मर्डर ट्रायल इससे रिलेटेड कि नॉर्मली या के मोस्टली जो है ना, वी डिड नॉट ऑप्ट टू गो फॉर डिफेंस एविडेंस or to come in a witness box under section 340 subsection 2. Why the reason?
It depends upon the facts of each case. If your case is of denial, फिर आपको जरूरत नहीं है. But if your case is of self-defense, you have taken a specific plea and you need to prove it, then you have to come in your defense in disproof of the charges alleged against you in the prosecution evidence.
तो बस ये थोड़ा सा असद आबादी साहब की आगे बढ़ाना चाहूँगा सवाल को कि अपने डिफेंस में, मतलब आपके कैरियर में कभी आपने किए 342 में कोई डिफेंस विटनेसेस वगैरह?
340 सब सेक्शन 2 में प्रोड्यूस किए हैं.
अच्छा, बट नॉर्मली कम ही होता है सर. इसकी वजह ये हो सकती है कि हम थोड़े से स्केर्ड हैं या एक बात हमारे दिमाग में डाल दी गई है कि ना करें?
जैसे पहले मैंने कहा, वेरी करता है केस टू केस. इफ द केस इज ऑफ डिनायल, then there is no fun in producing the accused on oath before the court. But if he has taken certain plea which he is unable to discharge otherwise, it is necessary, it is mandatory to produce him under section 340 subsection 2 if he has no other defense to. Evidence आकुलर की शेप में या आई विटनेस की शेप में इसलिए भी कम पेश की जाती है, ये सारे सुन लें. प्रोसिक्यूशन विटनेस तो पहले दिन आ गए, उनकी 161 की स्टेटमेंट हो गई. डिफेंस विटनेसेस नॉर्मली ड्यूरिंग इन्वेस्टिगेशन पेश नहीं होते, और व्हेन दे कम टू द कोर्ट फॉर द फर्स्ट टाइम टू मेक दैट स्टेटमेंट, उसकी वैल्यू वैसे डिमिनिश हो जाती है.
With effect of the case, he must be produced या evidence दे. अगर उसको 161 का स्टेटमेंट भी नहीं हुआ, then how we confront him कि उसने क्या इम्प्रूवमेंट किया, उसका क्या स्टेटमेंट है?
जो 540 के तहत विटनेस समन होता है ना, तो उसको फिर आप कन्फ्रंट तो कर नहीं सकते. उसकी अपनी जगह उसकी वैल्यू है, उसकी अपनी लीगल एविडेंशियरी वैल्यू है कि उसको कैसे कोर्ट ने देखना है, कैसे. खाली उसके डिले ही इटसेल्फ जो है वो उसके लिए फैटल हो सकता है. बिल्कुल दुरुस्त है. अब एक गवाह पेश ही नहीं हुआ, वो आता है तो आप उससे पूछते हैं ना कि आपने कभी बयान दिया था, तो उसका जवाब देते हैं मैंने बयान नहीं दिया. तो उसके बाद आप मोस्टली फर्दर क्रॉस एग्जामिन भी नहीं करते मास पे सजेशन देने के.
The cases fall within section 302B and 302C.
302C के हवाले से वो बड़ा इंपॉर्टेंट एस्पेक्ट है. 302C जो है वो फर्स्ट टाइम आफ्टर द promulgation of Qisas and Diyat Ordinance, یہ 96 سپریم کورٹ علی محمد کیس میں جو ہے اس کو جو ہے وہ ہائی لائٹ کیا گیا اور اس کو انٹرپریٹ کیا گیا. پھر کھوسا صاحب نے پی ایل ڈی 2015 سپریم کورٹ پیج 77 ہے زاہد عمران کیس, اس میں بڑا الیبوریٹلی ڈسکرائب کیا ہے. انہوں نے یہ کہا کہ جو اولڈ سیکشن 300 کی جنرل ایکسیپشنز تھیں, اگر ان میں کیس فال کرے گا تو وہ 302C میں آئے گا, جس میں تھا گریو اینڈ سڈن پرووکیشن تھا, ایکسیڈنگ رائٹ آف سیلف ڈیفense تھا, سڈن اکرنس تھا. تو وہ سارے جتنے بھی وہ تھے اس کی ایکسیپشنز سیکشن 300 آف دی ارسٹ وائل پاکستان پینل کوڈ, اس کی جتنے بھی تھی ایکسیپشنز, ان میں کو کیس کب آتا ہے تو دیٹ ول فال انڈر سیکشن 302C PPC. باقی راجہ صاحب بہت 302C کے حوالے سے ماشاءاللہ تجربہ رکھتے ہیں. ون آف دی موسٹ ایکسپیرینس لائر وی ہیو.
Any other question?
سر میرا کوشچن یہ ہے کہ وٹنس کے ہوسٹائل ہونے کے بعد اس کی جو 161 کی اسٹیٹمنٹ ہے, کمپلیننٹ جو ہے اسے کنفرنٹ کروا سکتا ہے, ایک کوشچن. دوسرا یہ کہ اگر وہ کنفرنٹ نہیں کروا سکتا تو اس کے پیچھے لاجک ہے.
یہ آپ کے چیمبر کا ہی کیس ہے, سرفراز کیس, پی ایل ڈی 2013 سپریم کورٹ 386, اس میں ایگزیکٹلی یہی ہوا تھا. اس میں سپریم کورٹ نے یہ ہولڈ کیا کہ پروسیکیوشن اس کو کنفرنٹ نہیں کر سکتی. اس کی جو لاجک انہوں نے دی وہ سیکشن 162 CRPC ہے کہ statement of 161 CRPC can only be utilized by the defense for the purposes of confrontation and for no other usage.
اس سے اگلا کوشچن میرا یہ ہے کہ اگر ڈیفینس وٹنس ہم پیش کرتے ہیں اور وہ ڈیفینس وٹنس ڈیورنگ دی کورس آف انویسٹیگیشن بھی پیش ہوئے ہو اور ان کی 161 کی اسٹیٹمنٹ ہو, دین جو کمپلیننٹ ہے, کمپلیننٹ کونسل پھر 161 کے ساتھ کنفرنٹ کروا سکتی ہے, کیونکہ اس کیس کے اندر تو لاجک یہ دی تھی کہ 161 کی اسٹیٹمنٹ جو ہے وہ کروپیشن کے لیے استعمال نہیں ہوگی. لاجک یہ ہے کہ
کسی پرپز کے لیے ایکسپٹ کنفرنٹیشن
جی, اور کنٹراڈکشن کریٹ کرنے کے لیے
فار دی ڈیفense.
فار دی ڈیفینس. اب اس میں کیا ہو,
اس میں بھی وہی پرنسپل اپلائی کرے گا
کہ نہیں ہو.
نہیں ہوگا.
تھینک یو.